Check, 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 check. Check 2, 2, 2. Check 3. 4, 4. 5. Check 6. 7, 7. Podium, podium, podium.
we're missing what happened with that.
I know the feeling.
Hey, how are you? Good to see you. I'm going first. I'm not used to that.
That's right, you're
I'm
on
so
that
used
side.
to being-
You're on that side.
Have you been in this courtroom?
Not to argue. I've,
Had a tour?
yeah. So I had a self-directed tour.
Oh,
I came in one day just to check the place out. And
something, huh? You're so,
yeah, it really
you're
is.
so close to I told you. I don't like
That's the best way to.
Yeah, I like them all.
I know. And then they were up high.
Yeah, that's
This
why.
kind of brings it down a little too low. Exactly, yeah. That's what we were just saying.
I'm the Italian. I'm not used to it.
Masha, did you argue it the last time?
Yes,
You did.
the first motion to dismiss. You're in the other courtroom, I think.
Right.
Yeah. That's why I got this case for trial.
Lucky you.
Draw near, give your attendance, and you shall be heard. Massachusetts, court is now open. Please be seated.
Good morning, Ms. Mellon. Ms. Slingerland?
Good morning.
Good morning.
May it please the court, Marcia Slingerland for the Commonwealth. We are here in this case on the second interlocutory appeal in this second-degree murder case. Very generally speaking, the defendant is charged with 5 counts of second-degree murder stemming from a fire set to a dwelling house in Lynn back on February 24th, 1999, in which 5 people died. The defendant made really 2 sets of statements in this case. On the 27th of February, 3 days following the fire, she made statements to the Lynn police and the state police, eventually confessing to the fire. 2 days later, at her arraignment in Lynn District Court, she made some statements to a court officer as she was walking down from the courtroom where she'd been arraigned back down to her holding cell. She made some statements to a court officer.
Now, that's March 1st.
That's correct.
Okay.
This court has already reviewed the first decision that the judge made. The judge found that the defendant, based on her mental impairments, and there was significant testimony about the defendant's mental impairments, he found that the motion judge found that the defendant's waiver of her Miranda rights was not knowingly, intelligently, and voluntarily made. That decision was essentially upheld on appeal in different words. This court found that the judge was well warranted in finding that her waiver was not knowing and intelligent based on certain findings he had made, that she didn't understand certain aspects of legal proceedings, the participants of players, and of that nature. This court overruled the judge with regard to the point at which custody attached, finding that custody attached later on during the statements the defendant made, so that some of the statements in that first set of statements on the 27th of February were suppressed and others were allowed into evidence.
Could
Go ahead.
Could you tell me, did the judge also conclude that she was incompetent to stand trial?
No, he did not. On March 1st?
Yes.
No. There was, the defendant was examined on March 1st by Dr. David Swenson, and pursuant to General Laws, Chapter 123, Section 15, Dr. Swenson reported to the court that he had a doubt as to her ability to consult rationally with her attorney and to understand the proceedings against her. Based on that, he recommended that further evaluation, she be hospitalized pursuant to that scheme, and that she be hospitalized.
Just for a little bit of background, where is she? Is she in jail? Is she in a mental health facility? Where is she?
As I understand it, she's in Framingham at this point.
And this is going on 6-7 years?
It is.
Now, on March 1st, when the judge made that, when Dr. Swenson made that statement to the judge, did the judge conclude that she was not competent to stand trial at that time, or did he send her back for further evaluation so that he could make that determination of competency?
Well, she was in Lynn District Court, wasn't she?
She was.
So there was no issue of competency, correct? Of to stand trial?
Not at that point. The record, you can infer from the record, Dr. Swenson examined, he recommended that she be hospitalized for further examination. And in fact, on March 11th, he says he examined her again in the Salem Superior Court, presumably for an arraignment in the Superior Court. So, and I have included in my record appendix the competency evaluation that was submitted to the court at the end of March 1999. So there was eventually a competency evaluation completed.
And that report stated that she was competent.
That's correct.
But on the 1st, the doctor had a doubt that she was competent.
Right.
And similarly on the 11th.
That's right. He recommended she be further committed. But that doubt is what the statute talks about, and I'd suggest that that's what the judge was saying. I mean, you can have a doubt based on anything, but the statute requires for a finding of incompetency clinical findings, and that's what the extensive report that was done at the Taunton State Hospital.
But just so that we understand, it's at the Lynn hearing in 11 days, it doesn't have to do with competency to stand trial. It has to do with whether he had the present ability to consult with her attorney. That's what's going on at the arraignment, correct?
Yes.
That's what Swenson is talking about.
That's correct.
And he's saying there was a doubt, using the statutory language, that the defendant maintained sufficient present ability to consult with her attorney to a degree of rational understanding.
That's correct.
That's what's going on in Lynn.
Yes. And so she's evaluated to determine whether that's in effect true.
And so he recommended that she become hospitalized, and she was.
That's correct.
But she was in fact arraigned in the Lynn District Court, wasn't she? Or we don't know that.
The record is not clear on that.
But the judge in the district court did not make a determination that she was not competent to stand trial at that point.
There's nothing in the record that indicates that.
Okay.
Well, there wouldn't be anything in the record.
Well, if she was going to be arraigned and she was not competent, there could be, couldn't there?
There could be.
They could defer her arraignment if she was not competent to be arraigned.
Well, competent to be arraigned, yes.
Yeah.
Well, now as I understand it, the judge has suppressed everything because it's not voluntary?
That's correct.
Everything.
Everything.
Well, everything at that...
There were statements made to the
on
court officer.
on March
March
1.
1st.
Okay, so
That's
it's not
right.
everything, it's a March 1. Right?
Originally, he had suppressed certain statements made to the court officer based on the fact that she was a government agent and she shouldn't have been questioning the defendant. However, originally, she had made some spontaneous statements. There was a conversation, a casual conversation with the court officer. It's following her arraignment, is the way it's indicated, I believe, in the record. And those initially were not suppressed because they were not designed to elicit an incriminating response. At oral argument on the last interlocutory appeal, defense counsel raised for the first time the possibility that these statements were involuntary. And this court declined to address it at that issue at that point, but allowed the defendant the opportunity to go before the trial court, which the defendant did. The parties stipulated below that no additional evidence was necessary and forwarded transcripts of two defense experts that the judge had largely credited in the first motion, along with testimony by Dr. Swenson and testimony by the court officer.
May I ask, would you agree that what was before the judge was the following: that the defendant had a history of hospitalizations, psychiatric history, epilepsy, saw spirits, thought that her cell was haunted, saw auras around people, was mentally retarded, schizophrenic, engaged in magical thinking, fixed delusions, auditory hallucinations, thought she had a tribal council that advised her, and that the judge concluded that there was a tenuous connection to reality, poor judgment, and unstable affect? All of that?
On March 1st.
Yes.
He had before him the information he had heard at the first suppression hearing, which was, yes, there was all that. The fact that she saw auras, she had a chronic condition, I think the judge was aware. She had a certain set of beliefs that was perhaps not mainstream. She believed in certain Native American rights, and that she had a tribal council that advised her. So she had this chronic state of how
That was in her head, right?
That was what she reported she believed. That's right.
Yeah, I mean, it was fantasy.
It was her belief.
She looks awful sick to me.
Well, she has been diagnosed as being mildly mentally retarded, functionally illiterate, and suffering from schizotypal personality disorder, which is characterized by psychotic episodes. On March 1st, when Dr. Swenson examined her, she saw auras around the defense attorney and the doctor. However, she accurately reported that she refused to take medication. There's a number of things that she reported: a history of epilepsy, a psychiatric history. She told this. She reported that her cell was haunted. She said that they think I set a house on fire and that her son was innocent.
What do you say the judge did wrong? Are
The
you
judge-
trying to get us to decide something that's factually based differently than him? Or do you say, where's his error of law?
His error of law is his conclusions are not supported by the facts he found. He did not find that her statements were the product of her mental impairments.
What did
He
you
You
ask
found that
for
there was a
finding?
reasonable doubt. I mean, you've got the burden to prove beyond a reasonable doubt that these statements were voluntary.
But the law is also clear that the statements must be the product of her mental difficulties. What he did was he did not make any findings as to her condition at the time that she made those statements, and the transcript was clear that there was nothing unusual about her demeanor. It was fine.
Ms. Lingerland, may I just ask you, did you go back in and ask the judge to make specific findings? I mean, it's your burden, right?
Right. Well, there was a motion in the trial court before the
No.
judge.
After the judge's findings on this time come down, which is October, am I correct? It's October 26, 2005?
That's right. I believe the defense counsel asked him to
Can I
make...
just, what have we been doing for 2 years?
The case was docketed in this court in July of 2006.
Well, what happened between 2005 and 2006?
They were assembling the record for appeal.
Okay. So, leaving that aside, did you go back and ask him to make specific findings? I mean, if you're Justice Glaney's point is, what's the legal error? If your claim is that he didn't make specific findings, don't you usually go back to the judge and say, Judge, could you make these findings? These are the findings. I mean, did you submit proposed findings?
I think I was not the counsel on the trial court, but I believe that the parties submitted memoranda, which I've included in the record appendix, setting forth their positions, what the findings should be. The judge made certain findings, and they're in his decision, but they do not support his conclusion that her statements were involuntary. In other words, the product of her mental impairment.
Is your argument that that the linchpin of the judge's finding of involuntariness is a statement that Dr. Swenson made at a competency hearing to the effect that he had a doubt lingering in his mind that she was competent, and that the judge picked up on the doubt that she was competent and somehow morphed that into a reasonable doubt that the statement was voluntary? Is that the essence of your argument?
That's part of it. He uses that doubt to support he makes findings. She's mildly mentally retarded, functionally illiterate, has this schizotypal personality disorder, and he says in his decision that is not enough to conclude that her statements made to the court officer were involuntary. However, that doubt that Dr. Swenson had confirms that the statements were not voluntary. And to the doctor's doubt, he adds his prior finding that Drs. Rosemarin and Kelly had concluded that the defendant had not made knowing and intelligent and voluntary waivers.
A couple of 2 days before. I mean, we're not talking about something. All of this testimony, or a lot of this testimony, related to her state on February 27th, right? Her mental state, and so we're talking 2 days later. He has all of that information, findings with respect to February 27th.
Right.
2 days later, another doctor says, I have doubt as to her competency on today's date, and she should be committed.
But the judge found that her statements 2 days earlier to the police officers were voluntary. And this court specifically pointed that out, that the judge had not been warranted and would not have been warranted in finding that the statements were involuntary. And she suffered from essentially the same condition that she had.
So the Miranda was not voluntary, but her statements on February 27th were voluntary.
In the sense that they were not a product of her mental illness.
That's
It doesn't, I mean, in fact, the judge here, as of March 1, doesn't just find that there's a doubt about competence. He says she was incompetent. I think that's probably not correct, because he's saying Dr. Swenson found her incompetent, but that is in fact not the case, correct?
That is correct. He does say at some point in his decision she was seemingly incompetent and not competent.
So is your argument that because he had earlier found that her statements before, 2 days earlier, were voluntary, there isn't enough in this record to support the change in the finding that now, 2 days later, the statements are involuntary?
There's nothing to suggest...
Is that your argument, essentially? On my...
It is. There is nothing really to support his finding that they're voluntary, particularly given his careful... Involuntary, I'm sorry. Particularly in light of his careful conclusions, which are on page 68 of the record appendix. That's his first findings with regard to voluntariness. During the police interrogation, in fact, the defendant would go off on tangents involving her Native American and other religious beliefs, some of which are irrational. But the judge said, you know what, the police were able to refocus her. She appeared...
Ms. Slingerland, excuse me for interrupting you. Let me ask you this. It seemed to me that part of what the judge was doing is saying it's one thing if you're being interviewed. It's one thing if you're being interviewed. This court officer was not interviewing this woman, correct?
That's correct.
She is, and I don't want to belittle, but she's sort of mouthing off, right? She's in a different situation. She's come before a judge. I mean, it may be that you are correct, but it strikes me that what he was doing in the earlier cases, even when people think, you know, it seems to me that it's conceivable in a very carefully constructed interview, you might be able to get somebody to focus. Whether that's the same, whether that necessarily means that when somebody's just been, you know, handcuffed and walking down with a court officer to a holding area, you know, when she is the court officer, I think is a woman, correct?
It is, yes.
Is clearly not interviewing this woman.
Correct.
I mean, she really didn't do that.
But the judge really didn't address anything about that. He just said he had a doubt, really not setting forth any factual bases. There was nothing about her demeanor, which was unremarkable. She initiated this conversation, the defendant. The court officer simply said, "Excuse me," which the judge found earlier had been a reflexive response to her statements. She was not emotionally upset. She cried and sobbed earlier. I mean, it's a much stronger showing, I would suggest, as to voluntariness with the court officer than it had been earlier.
Well, in a sense, what we're faced with is a beyond a reasonable doubt test, so that, and anyway, your time is up, so thank you.
Thank you.
Mr. Natola.
May it please the court.
Hilton's statements can be attributed largely to her debilitated condition. That's what the judge wrote, and it's on page record 106.
May I ask you this, ready to follow up on the questions that I just asked Ms. Slingerland? There's no question in this record that this woman has some kind of mental illness, but it is possible that people, and we know this, the case law is very straightforward, that the fact that you have a mental illness doesn't necessarily mean either that you're incompetent, and it certainly doesn't mean that statements that you make are not voluntary. So what is it about the circumstances as she's being led out of the courtroom and talks spontaneously to the court officer that would suggest that that wasn't voluntary as opposed to the police interview that was 2 days earlier?
Well, respectfully, Your Honor, I think the focus needs to be broader than that, because the standard of review is in the totality of the circumstances.
Correct.
So the totality of the circumstances must include the findings that the motion judge made about Ms. Hilton's condition a few days earlier.
Correct, but would the totality of the circumstances not include that 2 days earlier, talking about the very same substance, there's a finding that those statements were voluntary?
Yes.
Okay. So then I'm saying, what is different about this encounter, leaving aside competency, correct?
I think that I suggest that really the fundamental question that the court needs to answer is what was different is the following. And I believe it was Justice Cordy that asked the question about the linchpin, or maybe it was Justice Spina. And I suggest that the linchpin of this case is Dr. Swenson's finding on the date of the arraignment that there was a doubt as to Ms. Hilton's competency to...
It's not a competency.
He
He didn't say anything about competency. Did he actually say anything about competency, or did he say that at least... I've only looked at Judge Bornstein's findings.
There was, I believe that the...
There was a doubt that she maintained sufficient presentability to consult with her attorney.
Right. And
Isn't that what...
That's part of the legal standard of competency, though. Either one must...
But what does it have to do with voluntariness?
As the court, the key case that the court needs to look at, most respectfully, is the Hunter case, which is cited in my brief.
Yeah, I have the Hunter case, and I think that there is a difference. I mean, we've said that whether a defendant is competent to stand trial differs from whether he's able to make a voluntary statement, but the two do share common attributes, correct?
Yes.
But, I mean, isn't this very analogous to the finding that Ms. Hilton was not confident, was not able to understand her Miranda warnings, but that's different from saying her statements on February 27th were the product of her mental illness? I mean, isn't this similar? There may be a doubt as to her competence to consult with her attorney, but that would be different than whether the statements volunteered to the court officer were the product of her mental illness. And in fact, the judge had reviewed them before and didn't seem to have any problem with them the first time around.
You're right, Your Honor. And that's why I go back to Dr. Swenson's finding. It's that additional fact that the judge had on March the 1st that he didn't have on February the 27th, that when added to the information that he had regarding the 27th, tipped the balance, I respectfully suggest. And I suggest further that if he had that information, in other words, Judge Swenson made that finding within minutes of Ms. Hilton making the statement to the court officer. Of course, it would have been impossible for there to be such a finding on the 27th because she was in a police station house. But I suggest that if the motion judge had the same information about Ms. Hilton's statements on the 27th, he would have suppressed everything on the grounds of voluntariness. And most respectfully, I think he would have been justified in doing so.
Was Dr. Swenson expressing an opinion as to Ms. Hilton's competency when he used the word doubt? Or was he saying, you know, I've got some unanswered questions here. I would like to have her examined further and to resolve those?
I think it's probably the latter, Your Honor. But certainly, as this court said in Hunter, doubts concerning a defendant's competency, and that's what, I mean, we were talking about competency on March the 1st. And although Dr. Swenson clearly never said that Ms. Hilton was incompetent to stand trial. He never said that. So he did say that there were doubts. And what this court said in Hunter, coincidentally based on a statement by Dr. Swenson in that case also, which was identical to the statement he made here.
But the doubts that he had were expressed in the context of his desire to have further evaluation so that he could resolve those doubts.
Not so that he could resolve the doubts, but so that they could be resolved in the context of a fuller examination. And of course, they were resolved favorably to the Commonwealth, I suppose, in as much as Ms. Hilton was found to be competent by the people at Taunton State.
Mr. Natova, haven't we said that statements that are attributable in large measure to a defendant's debilitated condition, such as insanity, are not the product of a rational intellect or free will and are involuntary?
Yes.
And that's your position, isn't it?
That is my position, and that's what the motion judge found at page 106 of the record appendix here, when he said that Hilton's statements, can be attributed largely to her debilitated condition. And I
seems-
respectfully suggest that that equates with the product of her mental illnesses.
But he says, given that she was incompetent, well, no one had found she was incompetent on page 105. Consequently, given the conclusion that the defendant was incompetent to stand trial on March 1, and that she made a knowing voluntary, and she failed to make a knowing voluntary and intelligent waiver of her Miranda rights, her statements were not voluntary. Well, the first of that, he in the first decision, he said that did not make them involuntary. And the second of that, he's just wrong as a factual matter. She wasn't incompetent. I mean, we don't know whether she was competent or not, but no one had found her to be incompetent.
That's correct. Nobody had found her to be incompetent.
One of the difficulties with Judge Wallenstein's findings and conclusions is on the prior page of his decision. It seems to me that he more accurately reflects, maybe not because we don't have it, but since Hilton seemingly remained incompetent, so on the one hand he's saying she seemingly remained incompetent on that day, and then he says, because of that I have a reasonable doubt.
And I think
he's not saying, he's saying I have a reasonable doubt.
And I respectfully suggest that that's the key. On page 21 of the Commonwealth's brief, they write, contrary to the judge's findings, however, Dr. Swenson did not conclude that the defendant was incompetent or seemingly incompetent to stand trial. The judge wrote, what he ruled was that the testimony of Dr. Swenson confirms that a doubt existed as to whether she was capable of providing voluntary statements. And he says a little later that she seemingly was incompetent to stand trial. And I suggest what that language clearly is the judge drawing an inference based upon Dr. Swenson's testimony and based upon the other evidence that he had heard.
But I thought you just told me that Swenson's testimony was not an expression of opinion that he had in his own mind doubting her competency to stand trial, but the need for further evaluation.
That's right.
The judge misassessed what Dr. Swenson was testifying to.
I'm not sure that he did, and this is why I suggest that that language on page 104 of the appendix shows that he drew an inference from Dr. Swenson's doubt of that he testified to. That was his opinion, that he had a doubt about her ability to consult and so forth, that the motion judge drew the inference by using the word confirms that a doubt existed. And I suggest that that's the heart of the motion judge's ruling, not that she was competent or incompetent, because that's not the issue here. The issue here is whether or not the Commonwealth has proved beyond a reasonable doubt that her statements were voluntary. And where Judge Bornstein ruled that Dr. Swenson's testimony confirms in the judge's mind that there was a doubt, I suggest that's enough. Now, when he goes on to talk about seemingly incompetent, again, I believe he's drawing an inference, but it's really the key element is, in his mind, Dr. Swenson's testimony that confirmed a doubt in the judge's mind as to whether or not she was capable of providing assistance to her attorney and providing voluntary statements at the time.
Mr. Natola, could you help me just... You made a point, an interesting point, that Judge Bornstein had some additional information, namely the sort of psychiatric evidence about her mental capacity. In our earlier decision, and I again haven't gone back to look at the record, it says the judge found that the statement, and we're now talking about the police station statement, found that the statement was not the product of defendant's mental illness, but she had been coherent and rational. You know that part of the opinion. Yes. At that time, did the judge have before him the testimony that he refers to now in this decision, at page 11 of this decision, which was Record Appendix 105, that according to the testimony of Rose Malin and Dr. Kelly, as well as all the available evidence, Hilton failed to make a knowing, voluntary, intelligent waiver of her Miranda rights during a police interrogation?
He had the information about the psychiatric and psychological testing and that testimony before him. He also had, at that time, of course, the testimony of Dr. Swenson before him. And he was very careful, I suggest, to separate those things out because he could not apply Dr. Swenson's opinion or his testimony to what happened on February 27th because Dr. Swenson did not examine Ms. Hilton on February 27th. But the judge had all of that information on the record in front of him.
So I take it in summary that what you have is some events occurring at a police station on February the 27th. Some psychiatric experts thereafter, not on February the 27th, taking a look at what had happened in her history and so on and so forth, and testifying as to whether or not they thought she voluntarily waived her Miranda rights. And then you have an event on March the 1st where the psychiatrist is actually looking at the defendant on March the 1st, correct?
Yes.
Okay.
That's exactly the sequence. So,
I'm sorry.
Yes.
Mr. Natola, isn't it the case that back on February 27th, she said something not dissimilar from the remarks on March 1st? In other words,
Yes.
she said something about her son would hate her and never forgive her, right?
That's exactly right.
Which the judge found to be voluntary,
Yes.
right?
Yes.
But on March 1st it wasn't?
That's right.
Okay.
What do you say changed between the two dates?
Again, Your Honor, I suggest that the only thing that changed, and I think it's clear from the record, the only thing that did change is Dr. Swenson's examination of her on the 1st and his opinion. And that's why I suggest that I agree that is the linchpin of this case.
So both of you agree that the linchpin or the key is that Dr. Swenson said he thought she needed a competency evaluation, that she may be incompetent.
Yes. Yes, that was the added element.
But then that report came back that she was competent.
That's right. That's right.
I take it that the transcript is here as part of the record appendix?
It is.
It is.
It appears in the docket, 10 volumes.
It was lengthy, so that sounds like it.
10 volumes of the Swenson testimony at the Lynn arraignment is what I'm asking.
No, Your Honor. Oh,
No.
I don't believe that there is I don't believe that was ever preserved. What Justice Green is
No, I
referring to
understand
is
the
No, that's the
hearing,
first
the
motion.
Wallenstein hearing.
Well, we can't worry about that because you two agreed to submit it to the judge on the existing transcript.
That's right.
Without regard to anything that you might either obtain or reconstruct in Lynn. Okay.
Thank you, Mr. Natola.
Thank you.
Mr. Skeels, good morning.
Morning, Your Honor. I represent Marcus D'Amicus. He's appealing the denial of his motion to waive entry fees by a single justice of the appeals court on the grounds that, first of all, it's our contention that this is a quasi-criminal matter, and secondly, it's our contention that the procedures laid out in Chapter 261 of the general laws do not apply in this type of procedure, and there's an alternate procedure, as this court held in the Hunt case, to proceed under Rule 12 and move to waive entry fees under Rule 12.
So in that way, you are able to avoid, and I don't mean that in a bad way, the fact that he's got $1,700 in his account?
Well, this way, the definition of indigency under Rule 12, I suggest, is similar to the definition that exists in the federal courts on federal habeas corpus. The federal courts have held that the defendant has a constitutes due process right to have all his federal claims, heard a fair hearing on all his federal claims in the state courts. And if he doesn't get a hearing in the state courts, he has a right then to go into the federal courts on federal habeas corpus and get that hearing.
But if this is just for the moment, taking hypothetically Rule 12 out of the picture,
Right.
he'd be a dead duck because he's got that $1,700.
If, well, that would be true of a criminal defendant under the Commonwealth's logic also, because
He could pay the fee.
But isn't your point, though, that this isn't under, this doesn't fit under 27B? This is not commencing, or 27D, actually. It's not under 27D.
Chapter 271 is not mandatory. A person doesn't have to file for a waiver of fees under Chapter 261, because Chapter 261 specifically provides that he may file for a waiver of fees, not that he must file under that particular statute.
Okay, my question really was this. Under 261-29, it appears to be saying that it applies if an inmate brings an action. Now, this is an appeal from an adjudication that your client was a sexually dangerous person, right?
Right,
So he's
yes.
not bringing an action.
No, he's not bringing an action. He's taking
so
an
you
appeal.
so you would argue 29 and all its things about the prison.
Right. It wasn't meant to apply to this type of situation.
It's not a question whether it was meant to.
Right.
I mean, wasn't 29 enacted? Isn't the legislative history that Section 29 of 261 was because there was a concern that people who are incarcerated, serving lengthy sentences, bring claims of, access to facilities, violations of due process, and so on. Isn't that what we're dealing about?
Yes, that's quite true.
That is different from taking an appeal
Yes.
that the Commonwealth has commenced.
Yes, I suggest that's quite true. And the United States Supreme Court, I'd suggest, has made this distinction. They say that in the ordinary civil case, a person has no right to proceed, a constitutional right to proceed in forma pauperis. In the ordinary civil case,
But this is
not the ordinary civil case.
well, it's not. The issue of whether it's civil or criminal really doesn't arise in this sense. If your client had commenced an action saying that he had some problem in the proceedings,
Right.
5 years later, then we might have to address, correct, whether or not it was quasi-criminal, criminal, civil, sufficient for purposes of 261, and then you trigger the United States jurisprudence. But this is not a commencement of an action.
No, this is quite true. This is an appeal.
And if the answer to that question is, it is not a commencement of an action, that's the end of the case, isn't it?
Well, I'd suggest that's true, and that's the way it should be interpreted, because this, I'd suggest, first of all, this is under the decision of the United States Supreme Court, this is a quasi-criminal matter.
No. As a matter of Massachusetts state law.
Statutory interpretation.
Yes, I'd suggest as a matter of statutory interpretation, it should be interpreted so that we can proceed under Rule 12, and we do not have to proceed under Chapter 261. In fact, I'd suggest that's what the Hunt case said. I'd suggest also that under the United States Constitution, this is a quasi-criminal matter, and therefore the same rules that apply in appeals from criminal cases apply to this case.
Which is what, Mr. Skeels?
Well,
No fee is permitted at all?
The person has a constitutional right to proceed in forma pauperis. In the normal civil case, a person doesn't have a constitutional right to proceed in forma pauperis.
But who defines that? Doesn't state statute decide what in forma pauperis is?
No, the United States Supreme Court says that in a quasi-criminal matter, the Constitution applies. And, of course, the definition of indigency that the federal courts apply is not the same that the definition that's included in Chapter 261. The definition of indigency on the federal courts on habeas corpus would be similar to Rule 12.
So we accept the federal indigency standard for determining whether someone can proceed in forma pauperis?
Well, I suggest that the standard for proceeding in a quasi-criminal case should be the same as the standard which applies in the federal courts on federal habeas corpus.
Well, you're in pretty good shape. If you put the statute aside, 261 and so forth, then you get into Rule 12, as I understand this.
Yes.
And clearly $1,700, you're indigent. Right?
Well, I would suggest he certainly he would be under that situation.
I mean, that's all he's got, isn't it?
That's all he has, and the problem here is that he doesn't feel, I suppose, that probably that, and like a lot of people, that he probably doesn't have much of a chance on appeal, and he doesn't want to spend what little money he has left in order to take this appeal. This is the problem. This is why prior to 1960 there were only perhaps 10 criminal appeals.
On the other hand, an argument can be made that he isn't indigent because all his expenses and needs are covered by the Commonwealth. Are they or are they not? He's serving time.
Well, he has to pay for certain things at the institution. This is, I suppose, why the inmates have accounts, so they can pay for their fees for things at the institution.
Mr. Skeels, what do you say, forget 27D for a minute, but I think it also applies under 27B. What do you say to the fact that the appeal from Judge Duffley's ruling was not brought within 7 days?
Well, I think we mentioned this in our reply brief. First of all, Chapter 27, that particular statute, by its very terms, does not allow an appeal from a single justice ruling. In fact, in the Hunt case, this court held that you have to take an appeal under, I think it's Rule 15, and the 7-day rule doesn't apply to that.
All right.
Secondly, we're arguing here, we're proceeding under Rule 12 rather than under Chapter 260.
So would that also answer the question that the appeal should have gone to, is timely, but should have gone to a panel of the appeals court?
Well,
Why didn't it go to a panel of the appeals court?
Well, we asked for direct appeal appellate review.
No, you did, but one reason we might turn it down is you haven't gone where you should have gone in the first place.
Well, we weren't allowed to because the single justice denied our motion to
waive the fees.
For the fees.
And under Rule 12, that goes where?
Well, it normally,
we appealed to the appeals court.
It would normally,
you did. You appealed to a panel, and then we took it. Okay, that's fine. Now, this Clark case doesn't seem to add much anything to either side. This was purely a technicality on which he lost.
It had a very practical effect in this case. We filed a motion for free transcript in the Superior Court, and that was allowed. There was no problem. But then when we got to the appeals court, the Clark case had been decided after we'd gotten the free transcript.
Yeah.
And then we weren't able to get a waiver of entry fees in the appeals court because of the Clark case. That was the problem that we ran into in this case. And that, of course, means in the future, in other cases, we'll have a problem getting free transcripts and problem getting any kind of waiver of fees in this type of case.
Mr. Skeels, let's assume for a moment that we conclude that the statute, which has got some reasonably broad language, talks about commencing an appeal, if that's possible, applies. Right. Your client has enough money to pay for the entry fee, so what's the constitutional problem here?
Well, the constitutional problem is, I suggest, he has a right, because it's a quasi-criminal matter, to proceed under form of pauperis, under Rule 12, rather than under this 261. Under the MLB case, because it's a quasi-criminal matter, the same rules apply that apply in criminal cases. Now, the problem is, of course, if this procedure is applicable to people in this position, it's also applicable to people in the criminal matters. Our concern here is that under the government's logic, 261 applies to all inmates. Well, inmates are defined by the statute as including anyone in a state or county correctional institution. And 261 applies to criminal and civil matters. So if the government's logic is correct, then anyone taking an appeal from a criminal case who's been committed to a state or county house of correctional facility must also comply with Chapter 261. We have a rule of court, Rule 10, that says that all fees are to be waived in criminal cases. However, under the Commonwealth's logic, the statute trumps the rule of court, and therefore all criminal defendants would also have to apply with the provisions of Chapter
27B specifically states upon appeal in a criminal case. 27B on its face seems to me would apply to criminal
would apply to,
defendants.
that's the problem. If this
But
logic...
but the rule then
if this-
says there won't be a fee.
Well, but the Commonwealth says that the statute trumps Rule 12. If it trumps Rule 12, then presumably also trumps Rule 10, and criminal defendants have no right to proceed by filing a motion under Rule 12 or under Rule 10. This is our concern. This logic can now be applied to criminal cases. And the United States Supreme Court has said there's no constitutional difference between a quasi-criminal matter and a criminal matter. If this is constitutional for quasi-criminal matters, then it's also constitutional for criminal matters. And the same type of, and I'd suggest under the Rinaldi case we cited in our brief, it would be unconstitutional for criminal matters. That this procedure, I suggest, does not comply with the holding in the United States Supreme Court that in quasi-criminal matters, a person has a constitutional right to proceed in forma pauperis, and the rational basis test, which applies to most civil matters in determining whether such fees are constitutional, has no application to this type of case or to criminal cases. And this is the reason that Rule 10 provides for persons in criminal cases to have their fees waived, and it is the reason why Rule 12 allows a judge in a civil case to allow someone to proceed in forma pauperis.
Does the Supreme Court say that that the rules regarding proceeding in forma pauperis mean that the person appealing is entitled to appeal free of charge, or can the state set reasonable standards as to how much money the person should contribute?
Well, I think they said in the MLB case that I'm considering, they said that when it comes to quasi-criminal matters, the rational basis test has no application to that type of situation. We don't consider whether or not these fees are reasonable in determining whether the fees that have been set are constitutional. That test has no application.
So under the Supreme Court cases, the state could not charge all people $1 to file a criminal appeal.
Well, it might be able to. I'm not saying that is necessarily true. However, I think in the Rinaldi case, a similar situation where they said that the a criminal defendant had to pay for the appeal out of his inmate account, that procedure was unconstitutional.
But could the state charge under 27B, which has a proceeding for
Right.
having an affidavit of indigency, if Bill Gates were to file, I mean, could the state charge Bill Gates to bring a criminal appeal?
Well, under Rule 10, he wouldn't have to. He wouldn't be
Constitutionally, you're saying this is a constitutional. Could the state do that constitutionally?
Constitutionally. I think it does require some payment of fees.
So can't the state therefore constitutionally do some kind of individualized determination whether X defendant can or cannot pay a fee?
Well, that if it did, then that particular fee would not be tested as to whether it's reasonable under the rational
No, it would
basis.
be whether this defendant could pay it.
It would have to be tested under the same test as in NLB, and I'd suggest there would be serious problems in that case.
Thank you, Mr. Skeels. Mr. Hallas?
Good morning, Your Honors. My name is Benjamin Hallis. I'm a Special Assistant District Attorney for Middlesex. This court lacks jurisdiction to hear this case because the respondent failed to file his notice of appeal within 7 days of the order denying his request for a waiver, as was required by General Laws, Chapter 261, Section 27D.
Yeah, but he says that statute doesn't apply. So if that statute doesn't apply, then the 7-day rule, we don't even need to consider it.
Yeah, I mean, yes, Your Honor. Well, dividing sections from statutes. Chapter 261 has two different provisions that are at issue here. So if the court were to find that the entirety of Section 261 does not apply, then yes, Your Honor, you would be correct. However, the respondent's argument that the arguments, constitutional arguments, and the arguments about the fee waiver procedure rise and fall with the arguments about the appeal procedure is incorrect. These are two different issues. One issue is whether Section 27D or Rule 4 applies, whereas the other issue is whether the procedure of Sections 27A through 29 or Rule 10 and 12 apply.
I read 27D, but I don't see anything that relates to appeals arising in the appeals court or appeals arising before the single justice.
Well, Your Honors, it states that in any case where a court denies a request for a waiver of fees and costs pursuant to Section 27C or any other provision of law, the plain meaning of that language is that it applies to all cases. That would include cases on appeals. Additionally, Section 27B clarifies that overall the provisions of Section 261 control all cases, including appeals. Since the deadline is set by statute, it cannot be waived by this court, as stated both by the Clark case and the Friedman case. The respondents claim that he's filing under the rules of appellate procedures without merit for several reasons. First, the statutory deadline is more specific. It applies to fee waivers specifically, as cited in Section 27D, and it applies to appeals, as stated in Section 27B. Additionally, the rules provide that they do not modify statutory deadlines, and the respondent's interpretation that he gives would not make sense, since he argues that the party should have the option of deciding when would it wish to file under the rules of appellate procedure and when it wished to file under a mandatory deadline set by statute. For this provision, the respondent relies on the Hunt case. However, the Hunt did not state that Section 27D could be ignored, as the respondent claims. Rather, it stated the rules in the statute should be read in conjunction. Where there's a gap in the statute, as there was in Hunt, the rules can help fill in that gap in the statute. However, here there is no gap in the statute. Section 27D is explicit. It applies in all cases, and in all cases the notice of appeal must be filed within 7 days. The respondent claims in his reply brief that the Commonwealth's argument proves too much, and that under the Commonwealth's reasoning, criminal defendants also must apply for waivers because they are inmates. However, this isn't true simply because criminal defendants do not face a fee on appeals. Therefore, there is nothing to be waived. However, where a party does seek a waiver of a fee, it must comply with the procedure, the appellate procedure.
But the only reason they don't have fees on appeal is because of Rule 10. It's not because the statute would suggest that they should have a fee, doesn't it?
Your Honor,
27B?
I would disagree, Your Honor, in the sense that the statute provides that where there is a fee and someone is an inmate, well, again, there's two different sections of the statute. Section 27D applies on appeals, and the rest of the statute applies where someone is an inmate and seeks the waiver of costs. Therefore, if there were no fee, then the respondent wouldn't have anything to waive, and he wouldn't have to go through this procedure.
I realize that, you know, there are lots of statutory provisions here, and one of the problems is we've had some additions. The 27C says if the affidavit is filed with the complaint or other paper initiating the proceeding, and then 27D kicks into, you know, where the court denies the request as provided under 27C. The fundamental difficulty that I'm having here is so much of the statute seems to be driven by when an inmate or somebody else is initiating a proceeding, And you're saying an appeal is initiating a proceeding. Now, I understand that there are some cases, for example, which we may be at a divorce, you know, child support, but a criminal appeal doesn't seem, an appeal from a case which is criminal or quasi-criminal doesn't seem to me to be initiating a proceeding. Isn't that the fundamental crux
No,
here?
but Section 27D, if you read the rest of it, it says, in any case where the court denies a request for waiver, et cetera, pursuant to Section 27C, that would suggest beginning a case. But then it says, or any other provision of law.
Well, that might be.
Why does Section 27D only apply in cases where the complaint was filed by the person seeking the waiver of the fees?
Correct. That's my question.
Your Honors, there's two reasons. First, Section 27D, by its terms, states that it applies in any case where the denies request for a waiver.
Yeah, but don't you have to read it in context with the section that says, what is it, 27C, which talks about initiating or bringing a complaint, bringing an action in a court of the Commonwealth.
Yeah, but look at 27B, which talks about after commencing an appeal in any court.
Yes, Your Honors, I would urge the Court to look at the statute as a whole in terms of how the statute walks a party wishing to file for a request for a waiver of costs through the statute. Section 27A is simply definitional provisions, so it dictates to whom the statute applies, and includes in 27A that it applies specifically.
No, I understand all of that. The difficulty that I have is that 27D was you know, it's a 2004 statute. And one has to look at what the legislature is trying to do. I understand that 27B talks about or appeal in any court, but it seems to me that I'm having a really difficult time seeing why you're going to push all of these appeals into the statute within 7 days.
And, Your Honor, reading the statute as a whole, it is our submission that 27B dictates the terms to whom the statute applies. That's the initial part of the action that the Court must look to. It starts with 27B, and it specifically states that it applies on appeals. The next step is go to 27C, which provides what procedures apply. What does the Court actually do when it receives that request for a waiver?
Do you happen to know, Mr. Hallas, we've had informal pauperous proceedings in criminal, just straight out criminal cases. Do you know of any case where we have not permitted somebody to proceed because they didn't file a challenge to a denial of an informal pauperous within 7 days?
Your Honor, no, I'm not familiar.
So
let's assume
that there's an informal pauperous proceeding, and especially in the last few years, judges have been taking a pretty close look at the assets of people who claim to be informal pauperous, and their determinations that they can't proceed in formal pauperous, and you're telling me that if it turned out they wanted to appeal that and they hadn't done it within 7 days and couldn't continue their appeal, that we would say they were barred from an appeal?
Yes, Your Honor, precisely, because in that section, Chapter 261 does not apply.
Doesn't that run straight into the United States Supreme Court's jurisprudence? That somebody who has been convicted as a criminal defendant is barred from proceeding with the appeal because of a state statute?
Your Honor, the criminal defendant would not face Chapter 261, so there wouldn't be a statutory bar.
Why?
Because there are no fees and costs to be waived pursuant to the procedures in Section 261.
But there are.
It's only because
we
of the
waive them
rule.
as a matter of course.
Your Honors, again, I would urge that this statute doesn't provide that there must be fees and costs. It simply provides that where there are fees and costs and someone is an inmate, they have to follow a particular procedure.
No, but it could be a criminal case.
Yes, Your Honor. In that case, there are no fees and costs, so there's no need to go through this procedure. However, where there are fees and costs, and someone is an inmate,
there may not be fees and costs, but there are costs of expert opinions, or somebody files an informal pauperous, and as Justice Botsford alluded to, the defendant happens to be somebody who, let's say, the judge has reason to suspect is not lacking in assets, and so they have, the judge says, I'm going to deny the informal pauperous, and then at some point he doesn't file or she doesn't file within 7 days, and you're telling me that they can be barred because they didn't do it within 7 days?
Your Honor, are you speaking again about the criminal context?
Yes.
And again, Your Honor, I would urge that this simply would not be before the Court, because criminal defendants would not need to file this procedure, because there is not a $300 filing fee the same way that there is.
But there may be other fees and costs. I mean, you can't then say, well, I'm just going to cut this little bit off, right?
Well, Your Honor, and I would respectfully submit that's what's at issue right now before the Court, that the Respondent only has standing to challenge on a constitutional basis what is before the Court, and that is his status as a non-indigent, sexually dangerous person who could afford the fee but does not wish to pay the fee.
I have not done any, but I'm asking, I'm looking at when 27D was first added, and then what we're looking at, the copy that's in your addendum is from 2004. Do you know when this 7-day period of appeal was put into the statute?
No, Your Honor, not off the top of my head.
I think, well, maybe I'm wrong, but I think it was recent, but maybe I'm wrong.
Is the short answer to this case, without all this thing about the 7 days and all this other rigmarole, which may be important, but isn't the short answer, could be a short answer, that this fellow had $1,700 in his account. The fee is $300, as I understand it. His expenses are all taken care of because he's an inmate. Therefore, he has enough assets to pay the fee.
Yes, Your Honor. And I would agree completely. And turning to the constitutional argument.
Well, can I just place you on that? Let's assume we still have to, whether or not that constitutes whether or not he constitutes somebody who's eligible for a fee waiver, isn't the issue here how he gets that decided? It may well be ultimately on the merits. Somebody says, well, for an inmate who has, as Justice Glaney suggests, all of his things taken care of, $1,700, where somebody who, you know, is not incarcerated and has to pay for rent and so on, you know, you would make a substantive. But the question is, let's assume that the inmate wants to challenge whether, in fact, he can have the benefits of an informal pauperous rule. Isn't the issue how he does that?
And, Your Honor, I would submit that issue is not before the court because the respondent never raised that issue with the single justice. He never has argued that Justice Duffley's decision was incorrect in the sense that Justice Duffley incorrectly calculated the fee. And in fact, before Justice Duffley, he didn't make any statutory or constitutional arguments. Therefore, an argument such as that would be waived. It would not be before the court.
Now, that's what I'm saying. In a sense, we have to decide whether he could.
Additionally, Your Honor, constitutionally speaking, he would not be able to bring those arguments because he would not have standing to bring those arguments. And as the case law makes clear, if someone is not indigent, they cannot then challenge a statute constitutionally on the basis of indigency.
Wouldn't he, at the very least, if he wanted to say the $1,700 makes me, I'm still indigent, have to have a specific showing of why, you know, where was the $1,700 going? What's he going to pay it for, or what he has to pay it for? Just like someone, you know, in the civil context who's trying to get the fees waived, or some other context, has to fill out an item-by-item form on rent and debts and all that kind of stuff. And he didn't do that here. He just got an argument, well, I got $1,700, and, you know, we can use that for certain things down at the prison. That's not good enough, is it?
No, Your Honor, I would agree completely. And the only argument that's in the record is the respondent's statement in his affidavit, I am indigent. He also submits his inmate transaction report, but he does not then argue.
Why can't we decide the whole appeal on this basis? Why do we?
It fits within 27A-B, I would suggest. I mean, he is indigent, isn't he? He is a person whose income after taxes is 125% or less of the current poverty threshold, isn't he?
Yes, Your Honor.
So he would be, according to our statute, indigent.
Not according to the statute, Your Honor, because he is an inmate. And
well, that's right. If Section 29 applies to this kind of action, then you're right.
Right, but if it doesn't, then you're not right.
Well, the definition of inmate is actually contained, Your Honors, in Section 27A rather than 29.
Yes, but 27 itself after A doesn't use the word inmate ever. It just talks about a party.
Your Honor, I'm not familiar enough to be able to say one way or another if that's true. However, I would state that when a party is an inmate, a special procedure applies, and not the procedures that would be found under the normal procedure found in indigency, for the very reason that...
But what we have is very clear, it seems, and again, I don't want to just repeat it, it seems to me that there's a very clear theory about how what all of this is about for purposes of inmates. One is, you know, people who are appealing some, at minimum, criminal sentence, and then you get into whether or not, you know, if you get an order incarcerating you for, you know, potentially for the remainder of your life, that falls into that category, as opposed to inmates who are engaged in not civil proceedings, but proceedings especially where they are commencing litigation.
Well, Your Honors, it would be our submission that the legislature has included them, and the court needs to defer to the legislature's classification as long as it is not unreasonable. And here that classification is not unreasonable for several reasons. First, the respondent is an inmate. Therefore, most of his costs are taken care of by the state. He has this money to pay the fee in his account. Second, the respondent is a sexually dangerous person and therefore has many more opportunities for appeal and direct review on appeal than would a criminal defendant.
Okay. Thank you, Mr. Hallis.
Thank you, Your Honors.
Mr. Crouch, good morning.
Good morning, Your Honors. Andrew Crouch for the juvenile, Ronald R. May it please the Court. The juvenile appeals today from a decision by a judge in the Brockton Juvenile Court not to relieve him from the obligation to register as a sex offender pursuant to a proceeding that took place pursuant to General Law, Chapter 6, Section 178E, subsection F. The first issue I'd like to address is the juvenile's right of appeal from that judge's decision. At the outset, I'd like to note that at the appeals court level, the Commonwealth initially argued that the juvenile was not entitled to this relief from registration hearing. That argument, it's my understanding after consultation with the registry board, has not been pressed here. So for purposes of this hearing, we would rely on the brief for the argument that the juvenile, in distinguishing between juvenile delinquency findings and convictions, is entitled to such a hearing under Section 178E, subsection F. Here, the required hearing under subsection F was a necessary extension of the juvenile delinquency process. This was a situation that was not one that was indeterminate or not required. Subsection F requires a judge, a trial judge, within 14 days of sentencing to make this determination as to whether or not an individual should be relieved from the obligation to register as a sex offender.
Okay, if we agreed with you that the judge makes the determination and then that's an appealable issue, where would the appeal go? Would it go to the appellate division or to the appeals court?
I believe it would go to the appeals court. And this is an issue with respect to the second argument the Commonwealth makes as to specifically whether or not this is a situation that was necessarily brought, say, under a Rule 30A motion or one that should have been brought on direct appeal. I think, and this is one of the arguments that the Commonwealth put forward, that the additional argument was that potentially this should have been a 211-3 petition. I would say respectfully, this being part of being directly a direct consequence of either a guilty determination, be it a plea or a conviction, where there is not immediate confinement, it is one that is properly held on direct appeal. It is a matter that the individual here, unlike in 211-3, which is for extraordinary relief in circumstances where there is no other avenue for relief, I think the Hines case demonstrates that here direct appeal is indeed an avenue for the juvenile here, and I think that properly it should be before the appeals court and then work its way through the system as it has here. Specifically, this is not the hearing under subsection F is not a collateral matter. These are the cases that are discussed in the brief, such as Frere and Quisp, Rodriguez, where collateral has been defined in those cases as a matter that takes place not before this particular judge. I think the appeals court in Schindel does a good job of explaining that, indeed, even in the sex offender context, something is collateral only when it's decided in a different forum by a different fact finder or a different judge. If this was a matter that was before the Sex Offender Registry Board, that would make it collateral. If it was before a federal immigration court, that would be collateral. But here, Section F requires the judge to make this decision, and therefore, because it's in this court, it is not a collateral.
Well, isn't it a reasonable inference that the judge did, in fact, comply with the statute and consider the circumstances of the offense in conjunction with the offender's criminal history? The judge said that he understood that he had the authority to waive finding the person a sexually sex offender, but he was not going to do that in this case because he thought, based on the circumstances of the case, and can't we infer also the circumstances of the offender's criminal history, because the judge was very well informed of the entire proceeding, that the judge did comply with the statute.
I would say the first thing that I would say, for Your Honor, is that this particular section has been noted by the court in the Doe 3 case to be an important safeguard in terms of constitutionality for the entire statute. With that in mind, and keeping that in context, it is important for a judge to comply with all elements. I could say here
but
the judge...
Isn't the answer to Justice Island's question that the court is not supposed to determine whether whether the offender is relieved of registering or not? The legislature's made that determination. What the court is supposed to determine is whether the circumstances of the offense, in conjunction with his history, indicate he doesn't pose a risk of reoffense, and he never made such a finding.
That is correct,
and
Your Honor.
that's his function. His function is to make a finding.
That is the sole function. Now, subsection F suffers perhaps from some ambiguities. It doesn't lay out, say, burdens of proof. It doesn't make any other directions except for Justice Cowan's point that it is one simple finding, and in this case, that was not met.
Well, what I'm saying is, isn't it implicit that the judge may not have used the magic words, but the statute says if the court so determines, the court shall relieve such sex offender of the obligation to register. And since the judge said, I'm not going to do that, can't we infer that
I don't believe so, Your Honor. I think that what we need to do is, this is a very short hearing. This is a hearing that only goes over about 4 or 5 pages of a transcript. It starts, I think, from beginning to end, there are hints of the problems and the ambiguities in the statute. In the beginning, it starts with the judge asking, is there a motion pending? And indeed, the Commonwealth continues that, saying that this is the juvenile's motion to waive registration.
Well, there's no question the judge knew what the circumstances of the offense were.
Correct. He had just sat in a jury waive.
This involved a 6-year-old victim.
Correct. And this is something that certainly he had sat there, but the standard, which is the only thing that we have to go by in this case, as Justice Cowan stated, is not something that was actually found here in this case. Instead, he just said, based upon, I choose on the facts of this case not to do so. This was not something that actually followed the exact standard. So, the point that we would bring is that no, indeed, this did violate the juvenile's due process rights because the judge specifically did not even meet that standard, and it is the only thing that we really have to go on from subsection F's language is that we have the standard.
What were the judge's precise words?
He was, I know under the statute that I have the authority to relieve him from his obligation to register as a sex offender, but I choose on the facts of this case not to do so.
See, the problem that I see is his choice of, not to make a pun, but his choice of words, because he says, I choose on the facts of this case not to do so. He doesn't have a choice. The legislature has made the choice whether to relieve him or not. And he's got to make he doesn't have any choice. All he's got to do under the statute is make the findings, as I see it.
Correct.
Well, are you suggesting that the judge did not know what the offender's criminal history was?
There actually, to my knowledge, I don't think there's much of a reference to that. I think he goes through the sentencing process. So I don't know on the record if it's clear if he knows what the offender's history is. That's just off the top of my head. I don't recall if that was a previous issue. Now, I would think that in terms of common practice, it is likely during the sentencing process that the judge would have come into contact with that information.
So precisely what is wrong with what the judge did and said? What is wrong with it?
What is wrong is that I think that, first of all, there is the possibility here, distinct possibility from the first words out of the judge's mouth, that he has an incorrect understanding of what the burden of proof is here, placing that upon the defendant, whereas the statute clearly does not do that in comparison to, say, the lifetime community parole statute, as discussed in the Langgill case.
Well, the statute says that the judge has to determine whether the circumstances of the offense or the offender's criminal history indicate that the defendant does not pose a risk of reoffense. Now, doesn't the use of the word not suggest that it's the defendant's burden? I mean, how would the Commonwealth prove that the defendant is not a risk?
I think that this is perhaps one of the problems with the statute. And I think
but what I'm suggesting is it's not a problem. The word not means that it's the defendant's burden.
I think I would respectfully disagree. I think it is ambiguous, and that's in comparison. The best I think comparator we have is the lifetime community parole statute, which says specifically puts that burden expressly on the defendant.
Well, let's assume for a minute it's your burden. the defendant's burden. Then what is wrong with that, keeping that assumption in mind with what the judge said? If, as Judge Ireland points out, he obviously knew all the circumstances of this crime, and we can infer he was aware of the defendant's criminal history.
I think there are two main potential problems. The first one comes, as Justice Cowan noted, that it is the standard that was supposed to be applied here was not one that was expressly applied. In fact, it was on the facts of the case I choose not to do so.
And what's the standard?
The standard is specifically whether the circumstances of the offense, in conjunction with the offender's criminal history, indicate that the sex offender does not pose a risk of reoffense or a danger to the public. I think that one of the other issues...
Bring over some semantics that make no difference here. The judge's finding equates with that standard.
I would respectfully disagree. I think that it is a slight distinction, but an important one in terms of...
Could you just say it again to me slowly? Because I'm with you with... I mean, I've got 178 EF in front of me, and you are correct that what he is supposed to do is to look at the offense, the circumstances of the offense, and I have him here looking on the facts of this case. That's the circumstances of the offense, isn't it?
I would think so, yes.
And then we've got, in conjunction with the offender's criminal history, and I think just your answer to Justice Ireland was that this judge was familiar with the offender's criminal history, correct?
That is that would be a guess or an estimate. I think that through the sentencing process that is possible. I don't think there's anything that comes up in this hearing that specifically relates to that second part of the standard.
Okay, so you're saying because he didn't look at this offender's criminal history, that's the problem?
I think that is part of the problem, and I think that there are also, besides just what the judge did, I think there is also the possibility that there is the distinct possibility that there is some confusion over the specific burden of proof in the case, with the suggestion that it is indeed the defendant's motion, that the defendant has that burden of proof, which I would contend in comparison to the lifetime community parole statute that he does not. Also, the other additional argument that we make is that in this very short hearing, the Commonwealth at one point improperly refers to prior bad acts of the juvenile, uncharged bad acts, unconvicted bad acts, relating to the same sort of underlying offense. In terms of the facts, when the judge makes his determination upon the facts of this case, that doesn't, from that, we don't know specifically whether or not the judge is saying the underlying offense or if he's talking about the potential prior bad acts.
Community lifetime probation or parole, whatever it's called, does that actually articulate who has the burden? It does, and it actually specifically places that on the defendant. Okay.
And conversely, that is the same sort of thing that under 178E subsection E, it requires the Commonwealth to file a motion. Now under F, there is no placing of the burden. So I would say under cases like Lupo, Commonwealth versus Lupo, and the other statutory interpretation cases, that ambiguity has to be strictly construed against the Commonwealth in the defendant's favor.
Well, if the Commonwealth had presented a witness to give testimony about prior bad acts, would you be making this argument?
At that point, I think there would be. It certainly would have depended on whether or not the defendant counsel had actually made some challenges or objections.
My question is, does the statute contemplate the taking of evidence?
I think that
Could you have brought an expert in to say that my client does not pose a risk of reoffending?
I think so. I think so, Your Honor. I think that is something that defendants perhaps in future cases should certainly look at doing.
Maybe not you, but whoever represented this young man didn't do it. So
correct.
Now, even if the Commonwealth has the burden, haven't they met it simply by showing the circumstances of the crime and his prior criminal history?
I would say not. In this particular case, it is possible if this were remanded for a new hearing that I'm not saying that it's not possible that would be met if all of the due process procedural safeguards were followed. In this case, they were not followed, and that causes. And one of the
That's assuming we agree with you that all these other due process things of evidentiary hearing and all that stuff, written decision, so forth, are required.
Yes.
Were there any objections made to any of these points, or were there any requests that the judge file written findings? Were any of those things done?
They were not. And
so none of these issues was preserved?
Actually, I would respectfully disagree, Your Honor, and this is something that's brought up in the Commonwealth's brief. This is not a matter that is one that is brought under, say, 30A, or is one that is a situation where they're raising substantive issues or substantive challenges to the statute. Instead, these are simply unpreserved errors, unobjected to errors in terms of the process.
Counsel didn't ask for an evidentiary hearing.
He did not.
Didn't present an offer of proof as to any expert or
He did not.
Didn't present an offer as to any other evidence he might offer.
He did not.
Well, then
It's a question of substantial risk of miscarriage of justice based upon the articulated errors as laid forth in the brief and here at argument.
Now,
it is not an issue of waiver, though.
Is this issue of this particular statute, I know it takes place in conjunction with a juvenile case or a criminal case, but does the Sixth Amendment really even apply to this particular issue? Is it part of the conviction?
I think it does, Your Honor. I think that this is a direct consequence, a direct extension of the underlying criminal matter. It's something that's required by the statute. There is no break there's only a 14-day period of time. It's before the same court, before the same parties. This is not something that is a sort of an ancillary or collateral matter. I think that it's a natural extension of the process.
This would be a horse of a different color if defense counsel had tendered, say, an offer of proof from an expert, and the judge says, I'm not going to bother with that.
Yes,
I might have a due process problem then, but on this record, I don't see anything. I know you argue to the contrary.
Yes.
Okay. Thank you.
Thank you, Mr. Blache. Ms. McKenna?
Good morning. If it please the Court, Gail McKenna, Assistant District Attorney for the Commonwealth. To begin with, we're here on the appeal from an adjudication of delinquency, but here we are talking all about the sex offender registry and a collateral portion of what happened after the adjudication of delinquency was complete, which is what forms the basis for my first argument, which is that the Court does not have jurisdiction to hear this case.
Well, let me ask you, Ms. McKenna, are you suggesting that a decision of a judge of the juvenile court is then to be reviewed by an administrative agency, the Sex Offender Registry Board?
No, what I'm saying is that the next step is that the juvenile goes to the Sex Offender Registry Board, and the very first thing that happens is that entire process takes place all over again.
But then there's no appeal of the...
That's correct, Your Honor.
Ms. McKenna, I understand why, why that might be the case, but where the statute gives the judge, in essence, some discretion.
Correct.
I don't know of too many, you call it collateral. I don't know of too many proceedings where a ruling of a judge, can't be or should not be reviewed here. In other words, let's assume that the judge makes a an appellate court makes a determination that the judge in this case committed an error of law, such as one of the bases of the claims here, that he should have had an evidentiary hearing.
Well, Your Honor, first and foremost, the case has to be properly before the court.
Well, but what I'm saying is that much of what the juvenile is claiming here really might have nothing to do. Just take that.
Sure,
single point.
But if it has nothing to do with his criminal conviction, and that's the appeal before the court.
No, it's not that it has nothing to do with the criminal conviction. It has to do with a proceeding before a judge in a juvenile court that the legislature has authorized. There is a claim. Let's assume there's a claim.
So then the next question is, what's his route of appeal?
Yes, and the claim is...
And he has none.
No, the claim is that the juvenile here, that the way in which the judge conducted the proceedings violated his constitutional rights. I'm limiting it to that question for purposes of asking you the question.
Right.
That is not a question that can be decided by any administrative agency. It also can't be the case that if a judge acts in a way against any person in the Commonwealth that the person says violates some fundamental rights, either violates the statute,
Well, then
violates
that litigant still has an obligation to properly bring his case before the court. One way he could do that is through this court's 211(3) power.
That's possible, but
Right.
it can't be that there can be no judicial review. Do you agree with me?
I would disagree, Your Honor, and it's always uncomfortable to come before a court and say you have no jurisdiction, you can't review a case that
It's
the
not
court
the
may be.
case. There's a claim of improper procedure by the judge in the judicial branch.
Well, Your Honor, not every wrong has a right. This one doesn't have a right. The defendant doesn't have a right to be here making this claim before the court in this manner.
Would this same claim apply to an adult offender as well?
Yes, Your Honor.
So if we decide that he's got this right, then all decisions by judges to not waive or make them register are going to be appealable.
Along with the criminal case.
No,
And
but wait a minute.
essentially what the defendant is asking is for this court to overrule all of its jurisprudence that says that the judgment in the criminal case is the sentence is the punishment, and therefore somehow now something having to do with the sex offender registry is now punishment. The court has said otherwise. The judgment in the criminal case is the sentence that's imposed. That's what's appealed from. That's the judgment that comes before the court in a criminal case or in an adjudication of delinquency.
Is there any legislative history that helps us understand what they contemplated when they wrote this legislation, as far as whether there was a route of appeal, any information that helps us understand what the legislature was thinking about in terms of whether the juvenile judge has the final word here?
Well, I think the thing that's most telling is where in the statutory scheme this fits, and it's right in the statutory scheme with everything else having to do with the sex offender registry. There's nothing in here that is in the juvenile delinquency statute. There's nothing here that's in the criminal penalty statutes.
Doesn't it only apply?
It's completely ensconced where it should be in all of the due process protections and procedures that adhere to an individual who has to go before the sex offender registry board. And the greatest protection for an individual in this situation is that whatever this judge has done will be immediately de novo reviewed by the sex offender registry board, and he will have all the rights that this court has approved as meeting due process under the sex offender registry board
So
procedures.
if a judge determines that the defendant is not, does not pose a risk, the legislation, I take it, takes effect, and he is relieved of the obligation to respond or to report.
Right.
Does the judge's decision then get reviewed by an administrative agency?
No, Your Honor, and that's
The
one of the
Commonwealth
problems.
appeal that?
211(3) would be the Commonwealth's only recourse.
But then you're saying you could come up here all the time, anytime you were dissatisfied?
Well, that would be up to the single justice at 211(3), but we would have no recourse, and if the judge
Why
had
can't it go either to the appeals court or to the appellate division, which is the question that I asked in the beginning?
Well, the appellate division the appellate division of the district court.
Well, no, I guess it can't go to the appellate division of the district court because this is a juvenile court.
Right, and the
so
appellate
it would
division of
be
the Superior Court reviews only Superior Court sentences.
So it would go to the appeals court.
But there's no route of appeal that takes it. The statute doesn't encompass it in any way. It's just something that the legislature came up with as an attempt to give
So you're saying
another due process protection to people who may have to register as sex offenders.
Am I correct in understanding you that the Commonwealth could do a 211(3) or the defendant could do a 211(3) or only the Commonwealth could do a 211(3)?
Well, I'm not suggesting either, Your Honor. I think we have to wait until the case comes along and see what happens.
But you said if the Commonwealth disagrees with the ruling, you said it has 211(3), correct?
No, what I'm saying is if the Commonwealth believes that they can show the judge abused their discretion, which is the standard that would apply here, not whether that there's a substantial risk of miscarriage of justice, and we all know that that's an onerous standard.
I understand, but let's assume you all agree on the standard, so it's an abuse of discretion. Are you saying the Commonwealth can have a 211(3)? Does that mean that the defendant can have a 211(3)?
No, not necessarily,
You
because
can
the
try.
defendant...
You would have the right to bring it. The single justice may say no, but you'd have the
Right.
right to bring it.
Well, and the example that comes to mind for me is if the defendant were to appear in front of a judge who said, for example, I don't care what this statute says, I think everyone should register. Well, I would say that's an error of law and an abuse of discretion, and that they should take
But
their
if the judge
211(3)
makes
right.
the right, uses the right noises, as you contend he did in this case, the defendant wouldn't, according to your argument, couldn't use 211(3) because his remedy is with SORB.
Absolutely, yes.
May I just ask you a question, and it may just turn on the word convicted. Is it because, I mean, essentially what the statute says is a sex offender has been convicted of a sex offense, and then you get the or adjudicated as a juvenile, and then you go
Yes.
down to, and the legislature says to a judge, you can relieve of the obligation to register, right? And then the legislature says, but you can't relieve of the obligation to register in some very serious cases, and
Correct.
they very closely defined, correct? They really go
Yes.
to, I think, the heart of the sexual. Is it because the legislature has used the word convicted at that point as opposed to adjudicated that we even hear on this case? Because the
Yes.
fact, is that the only reason?
Yes, and my brother had referenced that at the appeals court I had argued that juveniles fell within those narrow exceptions too.
I know that. But
And I withdrew that argument after speaking to the Sex Offender Registry Board. They are the administrator of the statute, and in deference to their interpretation of the statute, I did withdraw that argument.
would it be
juveniles?
No, I understand the whole, and it may be
Right,
that
we
they are
treat them
correct,
differently
but-
for
but
good
would
reason.
Would it not be at least a reasonable argument, Ms. McKenna, to say when you are looking at the circumstances of the offense, never mind in conjunction with anything else, here you are really looking at circumstances that, other than the fact that of the use of the word conviction, are really precisely what the legislature has most expressed concern about, namely a very young child. The victim is a very young child with a very violent series of acts, correct?
I'm not understanding your question, Your Honor. I think what the legislature said here is what the legislature said, that for anyone who was coming within the statute here, what they wanted was for the judge to look at the circumstances of the offense.
Yes, but the legislature has, what I'm saying to you is that the legislature has indicated that certain circumstances, when you're dealing with adults who are convicted,
Right.
are so bad on their face that
Right.
you can never consider those.
Right, we're going to
Here-
presume they register.
Right. Here, the judge had that set of facts, it seems to me, correct, would clearly fall within the convicted of a sex offense involving a child or a sexually.
Right.
And the judge, recognizing that he retains his discretion because it's a conviction, not an adjudication, could well have said, look, this is precisely the set of circumstances that I'm not going to relieve. I mean, isn't that...
Well, I think what we have to do here is presume that the judge acted correctly under the law. There is a presumption of correctness. We have to presume that the judge instructed himself correctly because that is the law. I do want to add that there was no prior criminal history with this particular offender, so all we were looking at were the circumstances of the offense. It was clear to the judge that no motion was filed because this was part of the statute. It was self-executing. It came before the judge. He acknowledged that he was working under the statute before he made his ruling, and he said, based on the facts of the offense.
But may I ask you this?
Sure.
Why couldn't we just say that this was an offense which involved a conviction of a sex offense involving a child?
That's
End of story.
It's the word conviction rather than adjudication of delinquency.
I was trying to make that point, Ms. McKenna, by saying the judge could surely look, not to say he doesn't have discretion, but this is a set of circumstances which isn't even at the margins.
I would agree with Your Honor.
No,
I would agree with you.
on your broader argument that all of them have to go to SORB, is there something in the SORB regulations that says they examine these things de novo?
Yes, Your Honor, there is.
So if he goes over to SORB, SORB could say, well, we see the judge decided not to relieve you of this burden, but we'll look at this again.
Well, I don't think they're allowed to take into account what the judge, what the judge did or didn't do is irrelevant. They start de novo.
Does the regulations say that?
Yes, they do, Your Honor, and the regulations set out what they're to take into account when they're making their determination whether or not, and it's essentially the same, making their determination whether or not he has to register. So that takes place immediately thereafter. Essentially, this is another bite at the apple before the judge.
Ms. McKenna? Maybe I asked you this, but I don't remember. If the judge were to find that the particular juvenile is relieved from registering, can the Commonwealth try to do something before the board, to bring it back before the board?
No, Your Honor. It's a final decision. And as I said earlier, the only recourse the Commonwealth would possibly have
To 11-3.
Right, under the onerous burden of whether the judge abused their discretion. But again, the court should never reach any of these underlying issues because there is no jurisdiction in the first place. And as interesting as all of these issues are,
We should, because we've got to tell them how to do this, these other issues.
well,
Who's got the burden and so forth.
Well, I understand that, Your Honor, but the other problem here is that these issues are waived. They were never brought before the judge in the first place. So the judge never had first crack at dealing with any of these issues. There's no reason to believe that the judge did anything wrong, that he applied a wrong burden of proof, that, you know.
Well, I know that, but it would be helpful for the future for other judges to know what they're supposed to do.
I would respectfully say
I mean,
that the
suppose
court,
we say there got to be an evidentiary hearing.
well, under
Better
the
say
statute.
it today than wait for another case and reverse it.
Well, there's just been a large evidentiary hearing called the trial, Your Honor, with all due respect, and I would say that
Well, I
that
know it,
should
but I'm
suffice.
addressing just one of his arguments, you know, on how these things should be conducted and who's got the burden of proof, all that kind of stuff. It
Well,
seems to me to
respectfully,
be
Your
helpful.
Honor, I think it would be more helpful if the case came up on a full record, say under a 211-3 petition,
Yeah.
under a full record with
Well, we're
all these
arguing about two
issues
different
fully
things.
developed.
I'm saying to you, on this record, at least, you know, you may very well prevail if we even get there on the way this was handled, because his lawyer didn't do any of the things that he's now asking for. In the future, however, some lawyer is, and maybe we should clear this up now on what has to be done or not done.
No, and my only point, Your Honor, not to beat a dead horse, is just that it should happen on a full record. And I think that it would be more appropriate under a 211-3 record where all of these issues are preserved below and a trial judge has had an opportunity to make the right findings and to preserve his issues.
Why do we have all these trouble with juvenile courts down in your county? We just got done with Tobin Kearns and the ruminations about what the instruction ought to be.
It's me, Your Honor. I love to come up here.
Can I just revisit that, the colloquy you've just had with Justice Glaney? It seems to me that one of the difficulties here is, notwithstanding the ultimate outcome in the appeals court, and I recognize that it's a 128, but the appeals court went on to make certain statements. It is a 128,
Correct.
but as you and I know, with computers, if you're a trial judge in the juvenile court and you've got an appeals court panel saying,
Here's how you do it.
the judge was not required to do this, was not required, you know, and then trial judges go ahead and don't make findings, and then it comes up here, and we say, oh, no, you have to make findings, and we don't have any findings. I mean, that seems to me to be one of the problems.
But
I mean,
frankly, Your Honor, they're not constitutionally required to make findings, and usually the
Yeah, but
findings
that's on
are
the
pretty
merits.
clear.
That's on the merits.
And in a simple case like this, I think the findings are readily apparent.
I understand, but in any case, I mean, you see the problem.
Thank you all for your kind attention.
It goes around. The 128 goes around.
They certainly do.
Which is unfortunate because they aren't precedent, and I
Well,
know
in
that.
fact, as you may know, there's a huge constitutional argument about that in the federal court. So it's not entirely clear that we can simply say, well, they're not precedent. I mean, it's there's a problem there.
I understand that.
Well, thank you for helping us figure out.
Well, thank you all for your kind attention
Partially,
today.
anyway.
Ms. Peterson, I understand that you're going first and that you are limited to 5 minutes.
10 minutes, Your Honor.
Oh, I'm sorry, I have them back. So you will have 10 minutes? Okay.
And Mr. Suchecki's got 5, is that the?
Yes. Good morning, Ms. Peterson.
Good morning, Chief Justice Marshall, learned members of the court. My name is Attorney Jennifer Peterson, and I'm here today on behalf of the defendant appellant, Mr. David Blache.
Can I ask you a question right off the bat, please?
Yes, Your Honor.
Is your position, and I'm just not clear on it, and I'd like to be made a little clear, help me, in other words, on the mistake as to reasonable mistake of fact defense, are you saying that since there was evidence that the defendant came on to the victim and in effect was the aggressor in this and made advances, that she didn't appear all that intoxicated to him, and so he's entitled to the instruction of reasonable mistake of fact as to her consent? Is that your argument?
Yes, it's my brother's argument, Your
Okay,
Honor.
all right, I didn't know how you would write it. Okay.
Yes, he's going to be addressing it if the court allows us the mistake of fact instruction. And if I may, I'd like to address the wholly insensible instruction first. As this court is aware, Mr. Blache believes that this case raises the issue of how intoxicated, what level of intoxication in a complainant is sufficient to vitiate the defense of consent. And in order to decide that question, Mr. Blache believes that 2 issues need to be addressed. The first issue being what constitutes being wholly insensible, and the second issue is
Would you say that again? I'm sorry.
What constitutes being wholly insensible? What is wholly insensible?
Well, doesn't an average jury understand that? Most of them been drunk one time or another, and they know what wholly insensible means.
Respectfully, Your Honor, I would suggest that an average juror would not necessarily know what the term wholly insensible means.
So what should we say? What's the better language? Blotto?
Utterly stupefied?
I think utterly stupefied. I think this court got it right in Commonwealth versus Burke 137 years ago, and I think that's still good law. And utter stupefaction, I believe, is a valid standard here. At any rate, I think jurors should be made to understand that intoxication, if a person is truly wholly insensible, that they're temporarily unable to make any decisions regarding whether or not to consent to sexual activity. And I think in the instant case, the court's instruction was exceptionally confusing because of the testimony that came in. There was a good deal of testimony that came in regarding the standard for protective custody, .10, the standard for DUI, .08. There was a blood test in this case, and the complainant's blood several hours after the alleged rape came back at .14, I believe it was, but the retrograde extrapolation testimony was that at the time of the rape, the blood alcohol level of the complainant would have been somewhere in the vicinity of .176 to .24.
Well, wasn't there testimony that everybody reacts differently to alcohol, and some people can drink a case of beer and it won't affect them, and other people will drink a case of beer, they'll be just lying on the ground. I mean, to that effect. Wasn't there testimony that people react differently to alcohol?
I believe there was testimony in general.
Well, don't you need some kind of testimony, whether it be expert or something about the alleged victim, the complainant, as to that person's reaction to alcohol in order to get into this whole question?
I think, and what the defendant has proposed is a rule of thumb which basically says if the Commonwealth has evidence that a defendant was able to withhold consent, that they
You mean the complainant?
Complainant, sorry, excuse me. Yes, the complainant withheld consent, then that in and of itself is evidence of an ability to reason to the extent that particular complainant isn't wholly insensible.
Are we going to now have psychological examinations of rape victims?
No, Your Honor.
To see what their alcohol capacity is?
No, I don't think that blood alcohol level can be, you can't reduce wholly insensible to a blood alcohol level.
You're not.
Isn't the answer then just what you had in this case, which is all this evidence from all lay people that she was so intoxicated and so drunk, legless, to use a good word. And so the jury understands that because they know what that means. They've either seen people that way or been that way themselves or have seen movies or something, so that they get a sense that what wholly insensible means from the lay testimony, more than they in fact do from the expert testimony.
Yes, and I would suggest, Your Honor, that testimony is important that jurors hear. However, in this case, the instruction that the court gave was confusing. The instruction was that if complainant's condition as a result of being intoxicated is such that she is wholly insensible as to be incapable of consenting, then that's rape.
Well,
because
I wrote down what you said, though, before, and I thought you said something quite similar to that. You said we want an instruction that wholly insensible means temporarily unable to make any decision. And what you read me sounds almost exactly like that.
Yes, but unfortunately, the court did not define what constitutes being wholly insensible. It's clear jurors were stuck. They came back in the middle of deliberations and asked the court, can you please clarify what do you mean by wholly insensible?
May I ask, do you agree that the testimony was that the complainant had consumed beers, plural, smoked marijuana, had rum and coke, drank a lot, fell down several times, that she was described as way beyond drunk, that she passed out, fell back and hit her head on the wall, that she took her pants down, turned on the cruiser siren and lights twice, lifted up her shirt, licked the cruiser, and that other police described her afterwards as being very intoxicated and not steady on her feet?
Yes, Your Honor, I would.
And doesn't that all add up to being wholly insensible?
Your Honor, I would suggest that it doesn't, simply because I would suggest that the complainant here, despite being intoxicated, perhaps even highly intoxicated, was still in a position to make a judgment as to whether or not she wanted to consent to sex.
So the judge should not have given the wholly insensible instruction in this case.
We would argue that if the complainant was not so wholly insensible as to be able to withhold consent, then she wasn't wholly insensible.
Isn't that going to be a jury question? You've got all this evidence about how drunk she is, and then you've got evidence, I take it in this case, that, well, she testified, that I said, no, I don't want you to do that, I don't want that, or something to that effect. I mean, doesn't that all become a jury question? Why should you take that away from the jury, that they could weigh her alcohol consumption on this issue of consent?
Your Honor, I think that they can weigh it on the issue of consent. However, I don't think the Commonwealth should be relieved of its burden of proof. I think that in this instance, the jurors can take into consideration all of this testimony in deciding whether or not she consented.
If I
this
follow
is a
your-
he said, she said.
If I follow your argument all the way to conclusion, though, you're arguing that she shouldn't say no.
No,
you're arguing that the fact that she says no
takes it out,
takes it away, and
takes away the wholly insensible portion of it. That way, if she says no, then she might have said yes. Then it's a he said, she said, and jurors should be allowed to determine who's credible here. Is the
They have
defendant
that
credible?
Well,
or
now,
is the complainant
wait
credible?
a second. As I understand it, we've got, a lot of Commonwealth evidence that was just summarized, that she was really out of it. And you've got some evidence on your side that she at least had a minimal understanding so as to, consent. Your only quarrel here is with the words wholly insensible, right?
My quarrel is
You're not
with-
arguing that any of the evidence was improperly admitted?
No, Your Honor.
Okay. And as I understood it when you started, you said you would rather have the words utterly stupefied put in there.
Not necessarily. I think in order to further define the term wholly insensible,
Well, how
utterly
would you
stupefied.
define it? Give me the definition. What should the judge say?
That if a person is truly wholly insensible, that they are rendered temporarily unable to make any decisions on their own behalf regarding whether or not to consent to sex.
That looks
And
awful
here-
like what the instruction said.
I would disagree, Your Honor. Here, the complainant made a decision that she believed to be in her best interest. She testified that she said no. So in that instance,
My
the juror
colleague
should be
said
allowed.
that's an argument for the jury.
That's right. That's exactly what we're saying. That should be for the jurors to decide. But by giving the wholly insensible instruction, intercourse has been conceded here. So the only issue that to be decided was whether or not there was consent. And we're saying the jurors should be allowed to decide based on the testimony. If she was not so wholly insensible as to, if she could have said no, she might have said yes. And the jurors should get to decide that. Instead of taking it away and saying, oh, if you find evidence of intoxication, and then refusing to define what level of intoxication constitutes being wholly insensible. They went back with a protective custody manual that said 0.10.
Ms. Peterson.
It shows that you're intoxicated.
Ms.
And
Peterson.
they may believe,
Ms.
Your
Peterson.
Honor.
Your time is up, but I think Justice Botsford wanted to ask you a question.
Yes.
No, well, I was just going to ask, didn't they have all those options available to them? I mean, I guess if they heard she consented, they heard this instruction about being wholly insensible, wouldn't, even if she used the word utterly stupefied, or, utter stupefaction, it's still going to be up to them, and I don't understand what you say the judge took away from them.
The judge, essentially, proof of intoxication is a substitute for consent. The Commonwealth clearly proved she was intoxicated. So the question is, how intoxicated do they need to prove that she is in order to say, you know what, it doesn't matter if she consented or not. She was intoxicated, so therefore you don't even have to deal with the issue of
I
consent.
come back to this question I asked you before, I think. She said, but I didn't have the words in front of me, what she said is such that she is wholly insensible so as to be incapable of consenting. That says what you want her to say. You said you wanted her to say temporarily unable to make any decision. Well, she said insensible so as to be incapable of consenting. That's the same thing.
Yes, but in the defendant's instructions, defendant's proposed jury instructions, he made it clear that evidence of intoxication sufficient to prove operating under the influence, or evidence of intoxication sufficient to prove that protective custody was warranted, is not necessarily sufficient to prove that she was so intoxicated as to warrant taking this whole burden of proof to prove consent, which is the hallmark issue, the hallmark element of a rape case. And that burden has been lifted from the Commonwealth. All they need to do is prove she's drunk. How drunk? Who knows? The jury here doesn't seem
drunk
to know.
so that she's wholly insensible as to be incapable of consenting. That drunk. And that doesn't mean, plenty of these people have driven when they are under the influence, and they know that they weren't incapable of consenting.
I think your time is up.
Ms. Peterson, I think we understand the thrust of your argument. Thank you.
Thank you, Chief Justice.
Mr. Sucheki?
Good morning, Your Honors. The majority rule in the United States is that mistake of fact as consent is an available defense in a rape case. It is our contention in this case, since there was a wholly insensible instruction, Mr. Blache should have been able to introduce have read to the jury a mistake of fact instruction.
Can I ask you about that, though?
Sure.
Is it mistake of fact as to whether there was consent, or is it mistake of fact as to whether the complainant was wholly insensible such that she couldn't consent?
Or both.
It is exactly both. And the crux of the mistake in this instance is that Mr. Blache got to the point where he thought it was reasonable to assume that she could consent. Because during the course of the trial, Commonwealth witnesses were very specific. And in the Commonwealth's brief, they said that the defendant didn't point out to any suggestion that he had been confused or misled. And it's our contention that the activities of the complainant involved reason. The police officer, when he arrived, met Mr. McCrae, who had called
No, but
and
excuse
said,
me, in your answer to Justice Cody's question, that doesn't make sense on the facts of this case, because on the defendant's version, there couldn't have been a mistake of fact as to consent. What he said happened is that she was the aggressor, so he couldn't have mistaken her consent.
I disagree. Because of the wholly insensible instruction, the lack of consent is a mistake of fact. His belief was that she was capable of consent, and he had consenting sex with her.
But that's different. That's why I asked the very first question that I guess I asked to the wrong attorney. But Justice Cordy asked it. Isn't your position that the mistake of fact is as to her appearance that she wasn't too intoxicated to consent?
I don't know whether it's as appearance to it is the fact that he assumed, under the circumstances, that she was capable of consenting and did in fact consent. But because of the wholly and sensible instruction, that changes that. That makes it so that his idea of what consent was, his ability to rationally assume that her activities that evening, she may have been drunk, and that's not wholly and sensible. It's our contention that she made rational decisions that evening. She may have been drunken decisions, but that's not wholly and sensible decisions.
Do you agree that the judge erred by giving the wholly and sensible instruction?
I think if the judge went forward with a wholly and sensible instruction,
No,
in this
that's not my
instance,
question.
he had to do the mistake of fact instruction to be fair.
No. My question is, did the judge err by giving the wholly and sensible instruction?
Based on the facts of this case, I do not believe that the complainant was wholly insensible. And the reason...
So the judge, in your opinion, the judge erred by giving the instruction?
Yes, and if in fact...
Couldn't the jury have believed it so that...
That she was wholly insensible?
Yes.
I don't think it should have gotten there. I think that because we have the 20/20 hindsight of looking at what the jury did, the jury came back and said, well, what does wholly insensible mean? Well, that means that they didn't find that the complainant's testimony was credible, or at least they were going beyond that. Because her testimony was, if you recall, was that she was in the police cruiser, and the policeman had sex with her in the back of the cruiser. He without her consent. Boom, rape, gone. They're out of deliberations. That's the end. But that's not. They came back. His version of events were.
Can I interrupt you for a second?
Sure.
On this so-called majority rule on mistake of fact, two questions. First, do you know the exact number of states that permit it, and the exact number of states that don't?
I do not, Your Honor.
I mean, you could have a majority of, 24 to 23. That's not much of a majority. Why did you say majority rule?
Your Honor, I've got it from the ALR article 103 ALR 5th 447.
But do they do it as a matter of case law, or do they do it as a matter of statute?
Both. They actually combine them all. But if I may, Your Honors.
Can I ask you one other question?
Sure.
Did we say in Commonwealth versus Moran that we wouldn't recognize the mistake of fact?
No, Your Honor. My reading of the case law is that there are instances where it may be possible. And we think, in this particular instance, that the mistake of fact instruction should have been given because of the wholly insensible instruction.
When is the last time we said, in whatever case, we won't recognize it?
Your Honor, I do not have
Didn't we say in Lopez, I think it was 02, in Lopez in 02, that we haven't recognized it, we're going along with the minority of states that don't recognize it, but on the particular facts of a particular case, we might recognize it.
And in this instance, we think the
so
facts are such.
Your argument really comes down to don't recognize, stick with the don't recognize, but in this case, you're the exception. Because you're not going to ask us to change our mind in five years.
Well, but, Your Honor, in this case, because the wholly insensible instruction was given, the jury should also have had a mistake of fact instruction, because, if I may, the reasoning, the police officer he came to the door, the person who called the police said that she's going to come out here and tell you that I hit her because I called the police. And sure enough, she comes out and says, he hit me, and the officer investigates. He says, well, where in the face? There's no evidence of it. She made reasoned decisions. He asked her, what do you want to do with your car? She says, tow it because I don't want him to touch it. She does go into the police cruiser. She does turn on the siren. She's making conscious decisions.
Okay, well, we understand this, that you're saying there's enough evidence to permit a reasonable person
to
such
assume
as him
that she was capable of consenting.
Okay.
And that these people know what intoxicants are. And it's okay. It's legal to be drunk. It doesn't make you wholly insensible. And our position is that wholly insensible, the threshold should be to the point of lying just before unconsciousness, where the person cannot consent. So it is our hope, Your Honors, that you reverse the appeals court and find in favor of Mr. Blache. Thank you, Your Honors.
Thank you, Mr. Suchecki. Ms. Semmel?
Good morning. Catherine Semmel, an Assistant District Attorney in Essex County, appearing on behalf of the Commonwealth. I think there is really little question that the evidence of the victim's extreme impairment of this case was sufficient to warrant an instruction on incapacity to consent. The defendant, in fact, requested an instruction on incapacity to consent. The appeals court seemed
Wait a minute. You say capacity to consent.
Incapacity to consent.
Incapacity to consent. Is that an issue? Is that one of the Commonwealth's elements of proof?
Consent?
Yes. No. Capacity to consent. Is that one of the Commonwealth's elements one of the elements of the Commonwealth's proof?
I think it is, if consent is raised as an issue.
Yeah. Consent is an issue. But is the capacity, we're spending all this time focusing on capacity to consent, where consent is the issue.
But if somebody hasn't consented, then capacity comes into it.
What's your answer?
I don't think that the Commonwealth has to prove capacity to consent, but I'm trying to think why.
Because consent is the issue.
That's why I think, that consent is the issue.
Is it your position that the Commonwealth could take the position in a case that you've heard the complainant in this case? She absolutely said, don't do that. You should believe her. The defendant says, no, she said something different. But if you disbelieve the complainant, you can also then determine whether or not, in fact, she had the capacity to consent. So even if she said, even if she may have consented, she didn't have the capacity. Can the Commonwealth take both of those positions in a trial?
The Commonwealth can absolutely take both those positions
in a trial.
in
this case? Did you do that
As
in this
we did in this case. The primary theory of this case...
Then don't you have to follow that up with saying, but it's possible that if confronted by a complainant who says, and I was saying no, in other words, I was evidencing some capacity to understand what was going on, and therefore to refuse consent, in those circumstances where the Commonwealth is arguing in the alternative, should the defendant not be able to argue, A, I thought she was saying yes, and B, but if she was saying no, I was mistaken in my belief?
I think those are two different things. The reason there are two different things is this. In response to Justice Cordy's question, the Commonwealth is entitled to present alternative theories. They're entitled to marshal the evidence to argue alternative theories to the jury. Any theory that is supported by the evidence can be argued to the jury. I mean, the Court has addressed this with regard to joint venture in principle.
Well, if you're going to do that, don't you have to make the victim available for a psychological evaluation so that the defendant can introduce some psychiatric testimony or psychological testimony as to what her capacity is?
But what good would psychological evaluation be when the question, in this case at least, is how drunk she was at that precise moment, and by the time anybody could evaluate her psychologically, that would be long dissipated.
But we do that in insanity defenses.
I suppose, Your Honor, if the...
Is it a question that requires expert testimony?
Not in this circumstance. I mean, maybe you could make that argument, although I've never seen it made, if there's some physiological mental impairment where you get into what is... But in the facts of this case, it's just... This is common experience.
What is the capacity to consent? Do you need 80% capacity? Do you need 60%, 100%? What level are we going to define the requisite amount of capacity in order to consent or not consent?
I'm not sure that the Court should define this. I think that with regard to that there are other instances in which jurors are called upon on a daily basis to make determinations of how things like intoxication factor into other elements. Whether a person is incapable of premeditation because they're intoxicated. I don't think we provide any benchmarks to jurors in those cases.
Samuel, may I ask you this question? Let's assume the Commonwealth is proceeding on two theories, and that becomes obvious, namely that she said no quite unequivocally, and that she was so inebriated that she no longer had the capacity to consent. And the defendant says, I would like to bring in an expert witness to say that whatever the term capacity to consent means, if somebody is saying no, they are equally capable of saying yes. Therefore, in my opinion, she had the capacity to consent. Admissible or inadmissible?
As an expert, I suppose you could bring in an expert in that situation. I think the point of the alternative theories is that, yes, the Commonwealth presented evidence that this was by force. That was the opening statement of the prosecutor's opening statement, the first statement in the opening statement was that this victim was raped by force. But jurors may not have believed that. Jurors may have rejected, they may have looked at the victim's testimony about how everyone's testimony about how intoxicated she was. It may in fact have rejected the victim's own statement that she did resist by force. And in that situation, is the Commonwealth foreclosed from relying upon other evidence that shows an alternative theory of liability?
But if they're
Absolutely not.
If they're not foreclosed, if the Commonwealth can say, even if she said yes, or gave every indication of yes, you can still conclude that she didn't have the capacity to say it. If that, in fact, is permissible, why can't the defendant raise a reasonable mistake defense? That is, I reasonably believed she had the capacity to consent based on what she was saying to me and how she was acting. Why isn't that appropriate in those circumstances?
It's not appropriate for the reasons that I think this Court discussed at length in Lopez. It's not appropriate, not because it's an alternative theory or it's inconsistent. It's not appropriate because it's not a defense to rape in the Commonwealth of Massachusetts.
Well, it's not a defense because we've said pretty clearly that rape involves force, right? And if, in fact, the person is wholly insensible, you eliminate the force. You basically say the force necessary is simply the force to commit the act. So you take that out of it. So if, in fact, force isn't necessary when someone is wholly insensible, then how is someone to know? If force is necessary, we say, what do you mean? You must have known you used force. But if that is now off the table, why isn't the reasonable mistake on the question of whether she was capable of consenting?
Well, the legal point aside, Judge Cordy and I do not put the legal point aside because I really think it's determinative. But the legal point aside, the reason why it's not unfair, I think, is because how can you – I think it is difficult to imagine a circumstance where an individual is so incapacitated so as to be incapable of consent and this to be undiscernible by the defendant.
But how can you hold a defendant? You're the one that has to prove capacity to consent if you want to make it an issue. How is the defendant to know what her capacity to consent was?
Because there are overt manifestations. I mean, the
But
record
you're arguing if the Commonwealth says that there's sufficient evidence, because the Commonwealth cannot base an argument if there's not sufficient evidence, if there is sufficient evidence for the Commonwealth to argue that she was capable of refusing consent, right?
I don't know if that's specifically what we're arguing, but
you're saying she was not capable.
She was saying no, 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 therefore it was force, right?
Yes, correct.
If the defendant, if in fact there's a jury question as to whether she was saying no or yes, for the Commonwealth to then turn around and to say to the defendant, but whatever she was saying, as a matter of law, she was so incapacitated that you can't raise, as a matter of law, she was so incapacitated that you can't raise a mistake of fact. That, it seemed to me that we were quite careful in Lopez to look at the evidence. Here you have a jury coming back and asking, are you telling me that as a matter of law we can both believe that she said no, 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 because not all of us believe that she said no, 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 and then say, well, there's a different way to get to the same result. All you have to believe is that she was incapable of consenting.
Absolutely.
So the jury believes that she's incapable of consenting, but the defendant didn't believe that she was incapable of consenting, even though by I think you said it was clear that the jury may have rejected her testimony that she said no.
It could have. We have no way of knowing which the jury relied upon. Jurors may have found that he raped her by force over her objections and struggle, or they may have rejected her theory that her explanation that she struggled against him and said no.
Can I interrupt you for a second? This mistake of fact thing may be embedded in the instruction that you're supposed to give. The wholly insensible goes back to Commonwealth versus Burke, doesn't it?
Yes, Your Honor.
In that instruction, and I'll read it to you, and I'm sure you've read it, the crime, which the evidence in this case tended to prove of a man having carnal knowledge with a woman without her consent, while she was, now here are the key words, as he knew, incapable of giving consent, as he knew, wholly insensible. As he knew. Doesn't that imply a mistake of fact could possibly? And that's repeated in a number of other cases, by the way, in the appeals court and here, as he knew.
I think that those may have been the facts in that case, that as he knew, but I do not think that can overcome the clear statements of this court again and again and again and again that rape is a general intent crime, and that a defendant does not have to have intended or in fact have knowledge that the act is being committed without the individual's consent. That the courts couldn't have been clearer in that statement for decades.
But that's because there's an element of force. And what we're saying is when someone is wholly insensible, force is completely irrelevant. Because they're incapable of consenting. So if you complete the act, it's enough. And we've taken force out of it, so why isn't the issue of his or her reasonable belief as to consent relevant in that limited circumstance, the capacity to consent?
Because the intent is just not, his intent is in no way implicated in this offense. His specific intent, there is no specific intent. So it cannot be a defense. You cannot create that defense without reading an element into the statute that isn't there. And just a couple of months ago, I think in a different case, in rape by fraud, this court was very clear that it wasn't going to read elements into the rape statute that weren't there. And I think that this court explained painstakingly in Lopez why it can't be a defense, why legally it can't be a defense.
Yeah, we did. But didn't we talk about the fact that in our statute, because force is required, it's not necessary? The reasonable understanding of the reasonable mistake that the defendant might have had is irrelevant, where force is an element.
I think that the court spoke about it in the context that specific intent is not in there.
Yeah, but doesn't the complainant have to be virtually comatose for wholly I mean, they have to be stupefied or comatose.
They have to be
or asleep.
I don't think necessarily asleep, but certainly so severely mentally impaired.
The instruction we upheld in Milan, which I think goes to which is, I think, the most recent one, which we went
in which
Milan, Commonwealth against Milan, which goes to Justice Cordy's point about force is, there we mentioned sleep intoxication, drunkenness, stupefaction, unconsciousness, or helplessness. Is incapable of consenting. And then there's an interesting sentence. In such cases, the amount of force required may be only that sufficient to effectuate the act of intercourse. In other words, it's not the more, I hate to call these crimes straightforward, but where there's evidence of scratching and where the complainant, there was very powerful evidence that she tried to push him off. Here, and I think that's why we go back to the Burke. What were the underpinnings of the Burke theory about consent?
I'm not sure what your Honor's question was.
While you're perfectly correct that there have been cases in the intervening 157 years, we've been focusing more on the force piece of it. And if the question is one of force, namely she was saying no, 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 and he was forcing himself on her, then the incapacity to give consent really isn't at issue. And in those cases, it seems to me, a jury instruction on mistake of fact simply is not relevant because the evidence, and I think that's Lopez, that the evidence doesn't warrant it because there was no counter-argument in the alternative argument by the Commonwealth.
But if I may, it seems to me that you're saying that the complainant was so stupefied, and you look at the fact, one of the facts is that her blood alcohol content some hours later was 1.5 or whatever it was, and if you extrapolate from that, at the time of the event, it was probably much higher than that, to the point where she probably didn't know what was going on.
That's what the retrograde analysis determined, that it was probably between 0.17 and 0.24 at the time of the offense.
Was there testimony of how a person
Absolutely.
is at those high levels?
Confusion, disorientation, lack of memory, lack of judgment, lack of control. There was a lot of evidence about that, and I think that the court should be cautious about saying that you can ever have a reasonable mistake of fact in an incapacity to consent case, when in fact the standard, while it's not unconscious, as the defendant argued in their brief, it is a very high standard, and simply saying she was drunk but I didn't realize how drunk she was is not a defense in that case, aside from the legal arguments, policy as well.
Thank you, Ms. Samuel.
Thank you.
We'll take a short break.